Very good morning to all my dear students. I welcome you all into the Industrial Pharmacy 2. Dear student, we are on to the Unit 5 from Industrial Pharmacy 2 that belongs to the Indian regulatory system. The regulatory system or the regulatory requirement, these are the particular department of the government of India who are involved directly in the process of giving approvals that already we saw in yesterday's lecture. These are responsible for giving approval to the new drugs. These are responsible for giving approvals to the clinical trials. These are responsible for giving approval to the import and export of drugs, medical devices, biologicals, etc., etc. This department is also responsible for governing the manufacturing, sale, and distribution of these drugs, medical devices, biologicals, and the pharmaceutical products. So these are the things that already we saw in our previous lecture. And these are the points that we need to cover as per as the syllabus that is prescribed by the Pharmacy Council of India. So already the CDSCO, that is the Central Drug Standard Control Organization, which is situated at New Delhi, that is the central body of the India, which will be looking after of the process of approvals related with the new drugs and the clinical trials. So this will perform its functions solely along with that of the state licensing agencies. So the CDSCO has its zonal offices that are situated at these strategic locations throughout the India. As we saw in yesterday's lecture, it is situated at Ahmedabad, it is situated at Mumbai, it is situated at Ghaziabad, Chennai, Kolkata, etc., etc. Along with these zonal offices, there are some 7 to 8 sub-zonal offices are also there. Along with these zonal and the sub-zonal offices, there are testing laboratories. Now, all these are responsible for the process of maintaining these standards in case of the India. The laboratories that are responsible for the process of testing of drugs, medical devices, the samples collected by the inspectors from the manufacturers as well as from the medical stores. So these are the things that already we saw. We also gone through the organization and the responsibilities of the CDSCO as well as the state licensing agencies. Now we have to see the remaining, that is the regulatory requirements, the pathway, the procedure for approval for the new drugs, and the COPP. COPP, that is nothing but the certificate of pharmaceutical products. Today, actually, we have to see what are the different legal provisions that are provided as per as the requirements for the regulatory processes are there, for the approval processes are there. Then we have to see the different committees that are responsible for the process of evaluation of the approval process, evaluation of the clinical trials. We have to see the regulatory process, the data that is required that is pertaining to that of the new drugs, and the data that is required for the phytopharmaceuticals. So all these are the things that we have to see in our today's lecture. Now let's go through some of the rules that are prescribed or which will regulate the process of the clinical trials. So all these are the legal provisions that are given under the CDSCO for the process of regulation of the clinical trials. And that the very first is the Rule 21. Now this Rule 21, that is related with what? It is related with the process of application. Rule 21, that is the application for permission to conduct clinical trials of new drug or the investigational new drug. So whenever we have to go for the clinical trial of any kind of new drug or any investigational new drug, that is the IND, we have to follow the rule, we have to follow the guidelines that are given under the rule 21. Rule 22, that is related with what? The rule 22, that is related with the grant of permission to conduct the clinical trial. So we have to apply as per rule 21, and in accordance with that of the rule 22, we will be getting the permission in order to conduct the process of the clinical trial. Next rule is rule 23. Rule 23, that is dealing with permission to conduct clinical trial of new drug or investigational new drug as a part of discovery, research and manufacture in India. So wherever we want to perform the clinical trial in respect of these three different processes, like say discovery, research and manufacture, we need to follow the rule 23. Rule 24 is related with the process of permission to conduct the clinical trial of new drug, but that is already approved outside the India. The drug that is already existing, the drug that is already approved, not in India, but outside of the India. In such a case, in order to get the permission, in order to perform the clinical trial, we need to follow the rule 24. So all these are the rule 21, rule 22, rule 23, rule 24. The rule 21, that is for the process of application. 22, 23 and 24, these are for the process of granting of the permissions. Next, rule 25. Rule 25, that is related with the conditions of permissions for conduct of the clinical trial. What are the different conditions in which the clinical trials that will be permitted? All these conditions are prescribed, all these conditions are given, and all these conditions are in accordance with that of the rule 25. Then there is a rule 26. Rule 26, that is associated with the validity period of permission to initiate a clinical trial. That is the how much is the validity, or when we have to go for the process of the clinical trial. In such a case, in order to get the permission, we need to follow the rule 26. As far as rule 27 is concerned, it is associated with the post-trial access of investigational new drug or the new drug. So after getting the permission, we are performing the trials, and after the process of trials, whatever the matters related with the IND and ND that are in accordance, or the details are given in the rule 27. Rule 28, that is related with the academic clinical trials, rule number 28. Rule 29, that is for the inspection of premises related to the clinical trial. So the premises, the place where the process of clinical trials are carried out, that premises may undergo the process of subjection of inspection. They will subject to the inspections, and the details or the guidelines that are given as far as the process of inspections are concerned in the rule number 29 as far as the CDSCO is concerned. Whereas rule number 30, rule number 30, that is associated with the process of suspension or cancellation of permission to conduct the clinical trial. Let us say, for example, the place, the premises where the clinical trials are going on. But if it has been observed that the process or the clinical trial, these are not in accordance with that of the protocol, or if there is any kind of violation of the protocol, then in that case it is necessary, or the CDSCO will reserve rights to go for the process of suspension of permission or the cancellation of permission to conduct the process of clinical trials. So all these are the rules which will be responsible for governing the process of clinical trials. That is rule number 21, 22, 23, 24, 25, 26, 27, 28, 29, and 30. Rule number 21 to 30, these are in association with that of the regulation of the process of clinical trials. These rules are important and these rules may be asked in case of the GPAT examination. Let us say, for example, rule number 30. It describes what? You need to know that it is the rule which is responsible for the process of suspension or cancellation of the permission to conduct the process of clinical trials, right? So 21 to 30, these are in association with that of the clinical trials. Now, there are rules which will govern the process of import or manufacture of new drugs for the sale or for the distribution. And these rules are from 75, 76, 77, 78, 79, 80, 81, 82, 83, 84, and 85. So from rule number 75 to 85, all these are the rules which are responsible for governing, which are responsible for regulating import or manufacture of new drug for sale or for distributions, right? So let's see that what is the rule number 75. Rule number 75, that is associated with the process of application for getting permission to import new drug for sale or distribution. If we want to import any drug from outside of India, we need to apply as per the rule number 75. Rule number 76, in accordance with that of the rule number 76, the grant of permission that may be obtained for import of new drug for distribution or sale. Rule number 77, that prescribes all the conditions of permissions for import of new drugs for sale or distribution. Rule number 78, that is associated with the process of suspension or cancellation or the process of import of permission for the new drug. So the CDSCO may cancel, may suspend the application or the process of importing the permission for the new drugs. 79, the license to import new drug for sale or for distribution that will be given as per the Drugs and Cosmetics Act and the rules under their 1900 and the 45. So rule 79, that is in order to offer, in order to given the license in order to import the new drugs for the process of sale and distribution. Rule number 80, that contain the process of application for the process of permission in order to manufacture the new drug for sale or distribution of the new drugs. Rule 81, rule 81, that is associated with the grant of permission for the process of manufacture of new drug for sale or distribution. Rule 82 will gives all conditions of permissions for the process of manufacture of new drugs for the process of sale or distribution. Rule 83, that is for the process of giving license in order to manufacture a new drug for sale or for distribution under the Drugs and Cosmetics Act and the rules there under 1945. Rule number 84, that will retain all the rights in order to suspend or in order to cancel the permission which is given in order to manufacture the new drugs. Whereas rule number 85, that will contain all the responsibilities or that will gives guidelines, that will prescribes all the processes all the guidelines in association with the responsibility of the importers or the manufacturers in marketing of the new drugs. So rule number 75 to rule number 85 that are responsible for governing the import or manufacture of new drugs for sale or for distribution. In that, if you see rule number 75, rule number 76, rule number 77, rule number 78, these are responsible for the process of import, right? Rule number 71, rule number 75, rule number 76, rule number 77, rule number 78, and rule number 79. These are responsible for the import, whereas rule number 80, 81, 82, 83, 84, and 85, these are in association with that of the manufacturing. Note what I told you. I told you that roll number 80 to 85, these are in order to regulate the manufacturing, whereas rule number 75 to 79, these are for the process of regulation of import of what? Import of new drugs. Are you getting me? Yes, very clear. Now let's move to the different kinds of the committees which are there for the process of evaluation of the applications. So whatever the applications that has been made in order to perform the clinical trials and in order to perform the or in order to get approval for the import and manufacture, these applications will subjected to the process of scrutiny, these will subjected to the process of examination, these will subjected to the process of evaluation. And in order to evaluate all these applications, there are the committees. Now what these committees are, that we have to see. First, there is a IND committee. That is the committee which will look after or which is responsible for the process of evaluation of the applications for seeking grant or approval or permission associated with the investigational new drugs. So the evaluation of the investigational new drugs, that is the new molecules discovered in India, which is chaired by the Director General, Indian Council of Medical Research, ICMR, and the Secretary Department of Health and Research, that is DHR. So that is the IND committee. There is a SEC. SEC, that is the Subject Expert Committee. Now, Subject Expert Committee, it will consist of the 25 panels of about 350 medical experts in various therapeutic areas for the process of evaluation of applications of clinical trial and the new drug approval, except the investigational new drugs. For investigational new drug, there is a IND committee. But other than that of the IND or other than that of the investigational new drug, there is a subject expert committee which is responsible for the process of evaluation of the applications. There is a TC. TC is nothing but the technical committee. Now, this technical committee is the separate committee of experts which is chaired by the Director General of the Health Services to assist the apex committees. Which are the apex committees? Apex committees are nothing but the IND and the SECs, subject expert committees. So technical committee that will assist to these SECs and the IND committees in supervision of the process of clinical trials. There is a apex committee. So this apex committee that is responsible for the process of reviews of the recommendations made by the technical committee. Whatever the recommendations made by the technical committee, these will subject to the process of review by the apex committees. Now, what is the timeline and the automatic approval of the clinical trials? Earlier there were no timeline, but as the process that was subject to the application in the online mode, now the timeline has been given. So there is a timeline of 30 working days. Within the 30 working days, the CDSEO should give result, the CDSCO should take decision whether to permit, whether to approve the process of clinical trial for the new drugs or the clinical trials or not. Under the provisions of the sub-rule 1, where no communication has been received from the central licensing agencies authorities to the applicant within the said period, the permission to conduct the clinical trial shall be deemed to have been granted by the central licensing authority, and such permission shall be deemed to be legally valid for all purposes, and the applicant shall be authorized to initiate the clinical trial in accordance with these rules. That means what? The application has been made, and suppose if the CDSCO unable to give result, unable to give the decision, unable to make any kind of decision because of certain reason, then in that case it should be considered that it is valid and the application has been granted or the approval has been granted, and the applicant can proceed with the process of application, even though if the applicant won't receive any kind of communication within the 30 days. That is what is the meaning. Under Rule 23, Sub-Rule 2, the applicant who has taken deem approval under the provision to Sub-Rule 1, that means if there is no communication from the CDSCO in within 30 days, that is the condition. In that cases, shall before initiating the clinical trial inform the central licensing authority in form CT4A, and the central licensing authority shall on the basis of the said information take on record the form CT4A, which shall become part of the official record and shall be called automatic approval of the central licensing authority. If there is no communication by the CDSCO to the applicant within 30 days, applicant can proceed with the process of clinical trial, but the applicant has to report to the CDSCO in the form CT4A, clinical trial 4A. That is what is the meaning of this under Rule 23, Sub Rule 2. Validity period of permission to initiate a clinical trial. What would be the validity period? The CDSCO has given approval, then there is a fixed period of 2 years. Within this, after getting approval, within 2 year, the process of clinical trial that should be started. 2 years from the date of its issue unless extended by the central licensing authority. In special circumstances, this 2 years period that may be extended by the CDSCO. But normally the date from which the approval has been given, the 2 years, that will be the validity period in order to initiate, in order to start the process of clinical trials. Now, if we have to go for the application, that is the new drug application, then what is the data required? That we have to see in brief. We require the chemical and the pharmaceutical information. So this related with the all kind of information. Chemical information that pertain to that of the name, IPSC name, general name, common name. It is related with the molecular structure, it is related with the molecular weight, it is related with all the parameters, etc, etc, everything. It is also related with the pharmaceutical information, like say what is the therapeutic action, what will be the side effect, what will be the adverse effect, what will be the, yes, all these information related with the new drug that should be supplied, that should be provided in the application. There is a need to have the data pertaining to that of the animal pharmacology, that is the how the drug that will perform in case of the animals. There is a need to have the data pertaining to that of the animal toxicity, that is what is the severity, what is the LD, what is the lethal dose 50, what is the therapeutic index related with that of the drug, how the drug is safe, how the drug is toxic in case of the animals. Then there is a need to have the data pertaining to that of the different clinical trial phases, like say phase 1, phase 2, phase 3, and the phase 4, which will ensure the safety efficacy of the drugs in case of the animals. Then there is a need to submit the data associated with the regulatory status in other countries. If the drug is already working, already in existence in other countries, how the drug is going to be performing, that data need to be provided as far as the other countries are concerned. If we have to go for the process of importing, if we are importing any kind of drug, then the data related with the import, data related with the certificate of pharmaceutical product, that need to be provided. Then the different instructions, like say the labeling instructions, labeling instruction that is associated with the direction for use, that is associated with the storage conditions, that is associated with the warnings, that is associated